All right, so tonight's class it used to be named Notary 101, but we've changed it to the 5 steps of a flawless notarization. Because basically this is based all in whole on the NNA's book, 5 Steps to a Flawless Notarization. This is, being taught directly out of this book. So if you have this little book, then you already basically know what we're about to learn tonight. If you don't have this book, we're going to teach you. So, but I really recommend that you have this in your notary bag because you never know when you're going to need it. And then we're going to also do something here in just a second. I'm going to scan these in real quick. On a separate tab, if you could, I need you to open up your Google and I need you to pull up your state's notarial verbiage. I need you to pull up your state's notarial verbiage. So tonight we're going to be kind of doing a little something extra. We're going to do what we do normally, but we're going to do another little exercise as well. So the first step in a flawless notarization is personal appearance. Most of the time. Let me ask the question. Is there ever a time where the signer does not need to appear or does not have to appear at a signing? Someone come off mute or raise your hand and answer. Is there ever a time when a signer does not need to appear for the signing?
Yes, I think if they have a subscribing witness.
Very good. Or your is it subscribing witness? Let me make sure we get that terminology correct. If they have a power of attorney or someone attorney in fact, and I think you're right, subscribing witness. I have forgotten that term because
I just found that. I just got my primer, my state primer.
Yes.
And I was looking through that last night, and it's because it was giving the difference between a subscribing witness and a credible witness.
That's it. Oh. That's right. Subscribing witness. So that is the situation where your signer would not normally need to appear is in the event that there is a subscribing witness. Very, very good. Now that's going to be very, very, very rare, right? It's not going to be something you're going to run into often. But just be aware, because a lot of times I'll post in the group, I'll ask people, true or false? The seller must always appear for the signing. And inevitably, every few weeks, when we get a new group of notaries to come in, I have a whole bunch of people say, false. They've got to be there. And they'll answer in such a way that lets me know that they don't know about the subscribing witness. So It's always a good thing to be made aware of. Thank you very much, Tony. All right, so let's move on. I'm kind of using the replay last time as my PowerPoint because my PowerPoint, I accidentally deleted it off of my desktop. So now I've got to make exceptions. So number 2, step 2 is identify the signer. You have to make sure that you know what your state's rules and regs are when it comes to acceptable identification. What do we do in the event that we have a signer who appears female, but when we look at their driver's license indicates that they are male? This was a true or false question that I put up at one point, and it caused lots of good conversation that is very important to have, as a matter of fact. It was actually discussed in Professor Closen's book, Notary Best Practices. Does anybody know what they would do in that situation? No? Well, number 1, we always handle everything as we normally would as far as a professional level is concerned, but we ask questions, right? I see that your driver's license says Bob Johnson. However, you do not appear to look like a Bob. Would you care to explain to me the discrepancy, or would you care to explain so that I can understand who I am having sign this document? And if they feel comfortable with that, great. If not, then it's up to you as a notary, because it's your job. You are the last step in fraud protection. So it's your job to adequately identify the signer based on your state guidelines, what your state law says. If your state says that you have to use an active driver's license in order to verify the signer, and the active driver's license looks significantly different than the person that's presenting in front of you, then whether that person was male and looked female, or whether that person was 200 pounds on the driver's license and 50 pounds on the in person, you still, as the notary public, no matter what the variance is from, you still, as the notary public, are responsible for verifying this person. And if you don't see a close connection between who you have in front of you and who's on this ID that your state says you have to use, then you better be very careful before you proceed. Because again, step number 2 is your job is to identify the signer. You can do that either through personal knowledge, oath from a credible witness, reliable identification documents, and you always want to make sure you check signatures. How many signatures should you check on each signing? Anyone? Take a guess. When you're doing your signings, be it general notary work or loan signings or whatever, how many signatures should you be checking against each other?
At least 2.
2.
Good guess.
The
Which
journal and the document.
Your journal and the document. Okay, that's good. Those are good guesses. We're missing one.
Oh, the signature on the driver's license.
There we go.
Okay.
Absolutely. So every single notarization, you're looking at the driver's license. You let them sign the journal, which they should be signing at the beginning of the process. Okay. Your journal entry should be the first thing you do when you sit down to conduct a signing. Once you get their driver's license and they've signed your journal, you take a quick glance at that license. You look at it against the journal signature, and then you're good. And then not only that, you're going to come back, and once they begin to sign the documents, you're going to look at the document signature against the journal signature and so on, right?
So I have a question, Monica.
Yes.
So should you tell them to sign? Because I did this on my first one. I was so nervous, and it was someone I knew. I told them to sign the journal the way the name was on their driver's license. So if they had their full name on their driver's license, I asked her to put her full name on the journal. Was I supposed to do that or not?
No. And can somebody tell me why? When do we ever tell the person how to sign? Never, right? Now, when you're loan signing, and even when you're doing loan signings, they tell you they want the person to sign exactly as their name is printed on the paperwork. And
Okay.
as a former lender, I can agree. If the person doesn't sign exactly as it's printed, then it's going to cause problems. But you as the notary can never tell anybody how to sign their name. You can't enforce it. I can tell. Let me take that back, Tony. You can do that, but it really is not something that you want to get into the habit of doing. Their signature is their signature. Someone's signature could be an X. Someone's signature could be whatever they want it to be. You know, some states allow signature by mark. So if it's just a swipe, that's their right. Your signature is one of those places where nobody can tell you how to do it. Now, in the example that I gave of the loan signing, if you were doing a loan signing and you know the title company is going to kick it back and it's going to be all kind of problems, you can tell the signer, look, you can sign however you like. However, it will probably cause some issues with your delays with your proceeds if you don't sign it the way they have your name written here. But when it comes to your journal, you know, like I say, you could still do that. You weren't wrong. You weren't wrong by any means. It's just that, you know, the fact that they listened to you was fine. But if they had given you any pushback and said, no, this is my signature, I can sign however, then they would have been in their right to do so. I'll just put it that
way. Okay, thank you.
You're welcome. Good question. All right, let's move on to the next slide. Willingness and awareness. I gave an example in the group the other day of a refinance signer, husband and wife, and the notary and the husband and wife were at the dining room table. The wife is visibly kind of she's like scared. And the husband slams down the pen and says, sign. And the wife says, and she jerks a little and she picks up the pen slowly and she begins to sign. As a notary public, is willingness and awareness there for you on that signing? Would you, tell me who would proceed with that signing? This is a really good signing service now. They send you 4 or 5 notifications a day and you catch 2 of them, and the head lady has called you and said that she really needs to get these particular docs back in ASAP Rocky. Okay. And you're sitting at the dining table and you feel what's happening, you see what's going on. What do you do? Tony, what would you do?
I would stop this. I wouldn't go any further because she doesn't seem like she's willing to sign it, like she's being forced.
Right. Body language, conversation, all of these things are our job. You're almost like the police at a signing, because let's talk about what's happening at this signing. Significant amount of money and or assets are usually taken transfer from one place to the next when you come into play as a notary, especially in the case of wills and things of that nature. So when it comes to this being your job to make sure that everything is as it should be before this big transfer of whatever takes place, you got to take it very seriously. Let me ask you let's give you another scenario. Let's just say, COVID and the nursing home facilities were not allowing anyone in, and the sellers were, the husband was in the facility and the wife was outside. And the nursing home facility said, you know what, we can do this through a window. I'll hand the papers from the husband out to the notary, and then the notary can notarize it, and then so far and so on. Would you do that? Would you do that signing? And if you would, or if you wouldn't, tell me you wouldn't, and then tell me why. Crystal? Stephanie?
Okay, you're saying that the signer is the one in the nursing home?
Correct.
And the husband or the other person, the spouse, is not allowed to come in. So it's just you and the signer.
Well, it's you and the spouse on the outside of the facility, and then the husband's on the inside with the nurse, and the nurse is going to be the go-between. She's going to go get the doc, get him to sign it, and then bring it to the window and hand it out to you.
I would say no, because how are you able to evaluate the husband?
Okay, so a no from Tony. And what was that, Stephanie?
Actually, honestly, I'm not sure. I guess it would have to do with if the person signing is in their right mind. They just happen to be in a nursing home.
Right, exactly. That's a good point. Is you hit on it right on the head. You have to know if that person's in their right mind. Do you, as the notary, can you make that assessment in this scenario?
No.
Exactly. You cannot make an assessment. In Professor Closon's book, Notary Best Practices, remember Professor Closon is the leading most expert in notarial law in the country. That book is $30. You can only get it at the NNA. We read it. It was our first book in our book club series. In that book, he says he would not do a signing if the signer's whole body wasn't in his presence. Because even if you could see their top half, somebody could be holding a gun to their bottom half or a knife. Okay.
Wow, that's true. Yeah.
You have to be aware that it is your job. You are the fraud police. If someone is insistent on, he gives an example of a wife who needed something notarized. Her husband was bedridden and ill, and he, was in the back bedroom. The notary came over and she says, he's sick. He doesn't feel well. I'll run the papers back to him. She ran back to the back of the house, came back with signed documents. The notary notarized it. They were in the same house. Husband was just not feeling well, bedridden in the back of the house. The notary signed it or notarized the documents. The husband passes away. The wife gets lots of money. The children of the husband who passed had issues. It went to court, and that's where Professor Closon came in as an expert witness. And what happened in that case is that notary did not, number one, verify identity, because they didn't come in contact with the person, but they also didn't judge willingness and awareness. So I think he made it where his assessment of it ended up where the notary ended up being somewhat responsible for this because of that lack of determination, of willingness and awareness. Come to find out, the wife had her new boyfriend in the closet the whole time. So when I tell you that you never, ever, ever conduct a notarization where you can't see the totality of that human being, okay? If their whole body, half of them can't be in the pool and half of them can't be out, you need their body sitting present for that 10-minute ceremony, okay? Very, very important. Also, in the case of this scenario where we talked about the husband and the wife, I don't know if you guys would have felt comfortable doing so, but you do have the ability to ask to be left alone with the signer, especially if you're going to be doing notarizations in hospitals and things like that, where you've got a lot of family around. You may have one of the family members that's, being pressured into signing something that maybe they don't feel comfortable signing. Well, you won't know that if you got all the cousins and nieces and whoever sitting there in the room. So you as the notary, like I say, you guys, you have the power. At this ceremony, you are the boss. Act like it. Like you, whatever is what you determine what happens during that ceremony. And if you don't feel like everything is as it should be, then you stop it and you let it go. Because you don't want 10 years from now, 15 years from now, 12 years from now, for someone to come knocking on your door and subpoenaing you into court. Okay? So remember your power and use it.
I have that book, Monica.
Okay, yeah.
And it says that you're supposed to observe the facial expressions, body language, demeanor.
Yes.
Yeah.
Everything. You almost have to turn into somewhat of a, I don't know, pseudo-medical, psychological expert for 10 minutes. Like, how are we supposed to be responsible for all of this? But it's just common sense. If you can sense that something isn't right, or if you see the body language isn't normal of somebody who would express themselves to be willing to do something, then you need to make a judgment call. Okay, number 3, review the document. Are you supposed to read the document when you're doing notarizations? No, you are not. Netta is correct. You do not need this. It's none of your business, right? What if the document is in a foreign language? Can you notarize it?
If the certificate is in
Come on, Tony. Yes. That is correct. If the certificate is in your language, that's all you need to worry about, right? Because the document and the title of the document, you need to be able to tell what the name of the document is. And you also need to make sure your notarial certificate is in the language that you understand, because the nature of the document is none of your concern, right? Should you be typing and drafting documents for people then notarizing?
No.
Absolutely not. Exactly. All right, so review the document. Step 3, check for blanks. Make sure you notate the document title in your journal, the document date, the number of pages, the correct names of all signers, and just look out for any pre and post dating, okay? You can never pre or post date your notarial certificate, period, okay? The document may come to you and it already have a date on it. That's their business. But when it comes to the notarial certificate, you don't get to date that for any other day than the day you're actually conducting that notarization. All right. Step 4, detailed journal entry. So you've identified the signer, you've assessed willingness and awareness, you've checked over the document. Now you're looking at making sure your journal entry is like it should be. You've written down the type of notarization it is, be that an acknowledgement or a jurat, the date and the time of the notarization. Your journal entry should have all these details in it. I think there's 13 that Professor Closen indicates it should be in every journal entry for each signing. The start and end time of the notarization, why is that important? Can anybody guess? Well, what if I said,
oh, I'm sorry.
No, go ahead. Go ahead.
So in case you have to go to court, you can verify the times you were there and the time that you left and the type of notarization.
Right, exactly. And what's significant about being able to verify the time that you were there and the time that you left? What's significant about that?
You got me on that one.
Okay.
Other than accountability, you can attest to your whereabouts during that time.
True. True. What if somebody said, "Well, Janae was the one that told me that I should do this. I didn't know anything about this until she told me, she advised me. I thought, matter of fact, I thought she was a paralegal or something because she really explained everything to me and I really didn't understand it until she explained it to me." Okay. Now
Okay.
the judge is looking at Janae like, "Janae, did you do that? Were you engaging in the unauthorized practice of law?"
I'm like, no, I learned that not to do that in Notary Nerds University.
Exactly. I learned how to do that. We learned it in NNU also, that to make sure that I was able to show you, Judge, that because I started that notarization at 10 o'clock and that I ended that notarization at 10:10, that, I don't know about you, Judge, but I don't know how many attorneys could do all that explaining in 10 minutes.
Thank you.
Right.
Noted. Thank you.
So same thing with the fee. If somebody makes a claim that you did so much advising and counseling and this and that of them and only charge them $10, please tell me, where are they doing that at? Okay, so you have to make sure you annotate all these details in your journal to cover your butt. Okay, name, signature, and addresses of each signer. And in some states, thumbprints are not allowed. As a matter of fact, even though it is allowed in my state, I have made a personal decision, a business decision, to discontinue asking for thumbprints. Professor Closen recommends it in his book because he says that's the absolute 100% sure way to prove that the signer was present.
Right.
People can forge signatures really, really well, right? But you can't forge a thumbprint. However, his book was published before recent biometric laws have been passed. Biometrics are those things that eye scanners and thumbprints and different things that are part of our human body. And there's, I guess, some discussions about, is it right to do that? And if so, what requirements should one have in storing this information? So for those of you who are going to get into fingerprinting and be getting the live scan machine and storing fingerprints, even for a minute, you need to very well know sure what your state feels about that and where that fingerprint data needs to go and where it needs to be stored and how. So thumbprints are not allowed in all states, so you just kind of use your own wisdom when it comes to that. All right. Step number 5, complete certificate and apply seal. Use the appropriate certificate. What do I mean by certificate?
I missed the question. What was the question, Monica? I'm sorry.
What do I mean by certificate? When I say use the appropriate certificate, what are we talking about? What is a certificate?
Oh, the jurat or the acknowledgement.
Correct.
Right?
Correct. Exactly. So you get to decide which certificate to use as a notary.
No, you don't get to decide.
No, you do not.
But I have a question about that.
Okay.
I don't know what my notes are. It seemed like I read somewhere where a power of attorney is supposed to be an acknowledgement and not a jurat. Am I right?
Now that is good. I'm not sure about that.
Because I was like, well, if that's the case, then what if it didn't have the right wording and you wanted to do a loose certificate, but it's supposed to be an acknowledgement, but you're also supposed to not decide for the client.
Yeah, see, in that case, in that case, I would have always point the signer back to who gave them the document and have them ask them, what do you need to do? Are you swearing that this is true, or do you just need to have your signature acknowledged?
Okay.
You can ask them to do that, and then they can come back and tell you, oh, they told me I need to swear to this. Then that's when you'll know I need a jurat.
Okay.
Let's see here. Sorry, I'm gonna have to put him on mute. Excuse me. So see here. Also, make sure that everything is correct on the certificate. How many times do you double check your work? How long are you trying to hurry up and get in and out of your signings, or are you taking the time going back over your journal entry, taking your time looking at your certificate, or are you rushing and packing up and heading on to the next spot?
You should take your time. I've only done 2, but you should take your time.
You should definitely take your time because these documents may end up as a part of litigation. Always think that even if it's an insignificant document to you, it may just be a 1-page something or other. Okay, it doesn't even to you seem like a big deal. Always assume that every piece of 8.5 by 11 paper could end you up in court, and that you're gonna double check that certificate. You're gonna double check your journal entry, and you're gonna double check the certificate and the journal entry, and then just double check the document before you leave, because you're never going to see this person again 9 times out of 10, right? So you have to make sure that you take that one opportunity, because it has so much potential negative impact on you on the back end. Many of the court cases that Professor Closen discusses in his book happened 10 years after the fact. The notaries were probably doing other things, not even thinking about the notarization when they get the call or whatever. So you have to think in terms of every notarization. You have to think in terms of, okay, this paper could have me subpoenaed. What is it? Number one, oh, it's an affidavit. Okay, let me write that down. And then once you get done looking at everything and getting them to sign and doing everything, then you look again. All right. So it's never a bad idea to check your work 2 and 3 times, and even 4 if you need to, especially when you start doing loan signings. Excuse me. All right, any questions? All right, well, let's look at an, we're gonna do a little exercise. This is a really short class because that's it. There's only 5 steps to a flawless notarization. Does anybody have any questions about any of those steps? Because we're about to look at about to do a little exercise here. All right. I hope you have your, excuse me, state's notarial language pulled up. Oh, let me feed it through this way. There we go. Because we're about to, excuse me. All righty. See if you guys can see that. All right. How does this need to read in your state, Janae? Is this okay?
Let me. Actually, I just seen one just like that on Monday. So I'm gonna say yes.
Okay, well, let's look and see.
Let's see. Let me look, because I seen one just like that on Monday.
Who has their state law pulled up and can share their screen? Raise your hand. Okay. Because this is a Tennessee certificate. And so what we have to be aware of as notaries is when we get documents, a lot of times they won't necessarily, the certificate language won't be necessary according to our state law. The lender could be in Texas and the property could be in Tennessee, and the lender may have printed documents with their boilerplate state of Texas notarial certificate language, and the notarization is taking place in Tennessee and the property's in Tennessee. And you know, once that package hits that notary's desk, they need to be aware that, hey, this notarial language is not like mine. So the point is of this exercise is just to remind you that it's only your responsibility, nobody else's, to make sure that you know your certificate, your state's certificate wording. Now, can you handwrite a certificate? Is it appropriate? What if somebody needed you to notarize something and they don't have a certificate? You don't have a certificate. All you have is a piece of paper and a pen and your stamp.
Yes, you can.
Yes, I think, yes.
Yes.
Yes, you can. Now, if you're going to be handwriting a certificate, that means you need to know exactly what your state's language says, right? So it should be all of our responsibilities, mine included, to commit that to memory. You need to, on a dime, be able to write out your certificate if you needed to notarize something and didn't have a certificate available. I need to be on a dime able to write out a certificate, and I'm not there right now. I could not, without the help of a template, I could not do a notarization. So I need to make sure that I understand what my state's, and I need to go to my state's laws and get that language. As a matter of fact, I have mine somewhere, and I saw where they were spelling it out. It's not right in arm's grasp, but the point of the matter is this exercise is to remind you, go learn your state's notarial verbiage. Okay, so that if you ever needed to handwrite it out, then you could. And it's never a bad idea to print it out and tape it to the front of your journal if you don't think you'll remember it. Same thing with your oath verbiage. What do you have people do when you're doing a jurat? Is there any special actions that you have them take? Anyone?
Supposed to have them to raise their hand, right hand.
Good, good. If you're not doing so, like what Tony said already, start implementing something that signifies that this is serious. Do you please stand and raise your right hand? If they don't want to put their hand on the Bible, you can do all kinds of things, but this ceremony needs to be differentiated from any other ceremony. And the reason is because in Professor Closen's book, he says that they are on notice and everybody around is on notice that they're swearing to the truthfulness of the document, which means if they do that and something is found to be untrue, then they could be held liable for perjury. And that's a big deal.
Okay, Monica, on that one, so do you ask them which, because I think I read somewhere that some people don't want to say they want to swear to God. So do you have them to choose which oath?
Yeah, you can ask them if you would prefer to swear or affirm.
Okay.
And then they can make that decision. And so you then just use the appropriate language after they made the decision. That's actually even honestly, that's another good step, because if you take the step and if it's in one of your best practices, that when you're doing a jurat, that you ask them their preference, you need to make that note in your journal. Ask signer oath preference. Make that notation in your journal every time you do a jurat, because it will go to show you your diligence, okay, and your consistency in making sure you ask every time. So let's say you give a jurat, let's say you administer a jurat for someone that is actually doing some fraud and ends up lying. Everybody's in court and they subpoena your notary journal. And the person is saying, she didn't make me swear. Y'all can't hold me up for perjury because I didn't even swear. Prove it. And then the judge will open up your journal, and Professor Closen will probably be the expert witness, and they will flip through your journal, and he'll see every time you have a jurat listed, you have this little note that says, asked signer oath preference, asked signer oath preference, asked signer oath preference. And every page he flips and he sees a jurat, he sees you consistently doing this every single time. Well, you know what Professor Closen is going to say? And not only that, he saw that on the journal entry in question. So now that person claiming that he didn't know, that person claiming that he wasn't under oath is not going to hold as much weight, because there's this document now of every time you've done a jurat, you've said ask signer oath preference, including the signing for him. So that's how this thing ends up helping you. That's how being a diligent note taker in your journal can save your grease, okay? When it comes to these notarizations, because people is out here in these streets doing all kinds of bad stuff, and it's getting even more slick and slick and slick, okay? So scams and scams on scams. So just everything is a scam to you, like, until it's proven otherwise. That's how serious it is, because even your E&O and none of that stuff protects you. They can come after the notary completely. Okay, one last thing, and then I'll take some questions, and then we'll get ready for meet and greet. one of the very first things that attracted me to Professor Closen and a young lady by the name of Cecilia Cannon, I think, was a story they shared on an NNA video on YouTube. And I listened to the story, and it was about a man who was a boss in his notary, 60 some odd year old notary that was a secretary or his assistant. And he had a custom of dropping documents on her desk, get notarized. No big deal. She did it all the time. She knew him. And so she da. Well, he was up to no good on one of these days. But she had always done this. So she notarized the documents. Well, they asked her, he got caught up in the situation, and they asked her under oath, did you do this? Oh, did you administer an oath or affirmation to him? And she says, well, no, he just always laid the documents down, and I never, he's my boss, and I knew it was him, so I just notarized them. Well, because that was the case, he no longer was going to be able to be held liable for perjury. So the whole criminality of that case went and fell by the wayside, which is another thing, and that's going to be it. I promise you. I said one thing, but there's another thing. If there is an issue with the notarization, what's happening now is if there's criminal activity and stuff like that, people are doing bad stuff, the first thing they go check is to see if they can get it tossed out for a bad notarization. And this was another NNA video from an attorney, and I can't remember the name of the case, Kleisick versus somebody, but what had happened was he was on vacation, the notary signed something, he wasn't where he said that they, should have been, or whatever the case may be, and the criminal activity that was happening in the background got pushed to the side because the focus of the whole case became about the notarization. He wasn't even there at the time of the notarization. We don't even need to talk criminal stuff because we're getting ready to get it thrown out based on that. So your job as a notary public is so very important. And it's even more important for you not to rely on anybody to know your state's laws. And that right there is the thing I'm going to leave you guys with. Now tell me if you have any questions that I can help you answer.
I had to step out the room for a second, but could you go back and tell me the reason why you said you stopped doing the thumbprint?
Yeah, so the thumbprint is, in some cases, biometric data is what a thumbprint is. And there's new laws that are being passed about where you store it, how you send it, and this and that and this and that. And in Professor Closen's book, he teaches us to get a thumbprint because that's undisputable evidence that that person was actually there at the signing, right? Well, his book was published before all these new biometrics laws started getting passed. And some states will prohibit you from taking a thumbprint, and others, like mine, allow you to take a thumbprint, but they don't require it. But the question still becomes, who's responsible when you have somebody's thumbprint? That's a biometric piece of their data. That's something that you have to be careful with the storage of. So I was saying, for me personally, I made a business decision to discontinue requesting them. That does potentially give an issue because, if somebody's good at forging somebody's signature, I'm not going to be able to tell. So that thumbprint would have saved me from, save the situation if it gone to court. Hey, here's a thumbprint. We can just connect the dots and see if they were there or not. However, it also is important for me to know that if I save somebody's thumbprint in my journal, that could ultimately end up in court one day. Somebody saying, hey, look, I didn't want her to keep my thumbprint. So you have to kind of weigh the pros and the cons, all the while looking at your state to see exactly what they say you can and can't do.
Okay, thank you.
You're welcome. All right. I need you guys to get a little bit of a break. It is 7:41. Join us back for Notary Meet and Greet in 19 minutes. This was it for 5 Steps to a Flawless Notarization. It's a really simple and quick class. It's really just like a refresher. I will upload this replay into the class probably tomorrow morning after because the Notary Meet and Greet is going to be running to about 10. So I don't think it'll be uploaded tonight. But yeah, if there's nothing else, I'll see y'all here in a few.
Okay, see you later.
See you later.
Thank you. See you soon.
Thank you.
Okay.